to appear before the board. Mr. Glossip will be able to view the entirety of this proceeding by Zoom. However, will only appear during his presentation. Mr. Glossip's legal counsel will speak to the board first for a total of 40 minutes. Mr. Glossip's legal counsel may reserve up to 5 minutes of that time for rebuttal. The 5-minute rebuttal time must be requested in advance of your presentation. We have received notice that Mr. Glossip will be represented by his attorney, Mr. Don Knight. And Mr. Knight, when we go to you, you'll share with me who the other representatives are and name them for me. Okay.
Thank you.
The board members will reserve any questions till the end of the presentation. Immediately following Mr. Glossip's legal counsel's presentation, the Oklahoma Attorney General, Mr. Gettner Drummond, will be given 40 minutes to make a presentation on behalf of the state of Oklahoma. Attorney General Drummond may also reserve up to 5 minutes of time for summation, and that 5-minute summation time must be requested ahead of the state's presentation. And Mr. Attorney General, I'm aware that you have other people and you'll be able to identify them when you begin your presentation. Thank you. The board members will again reserve any questions for the state to the end of the presentation. The board will then take a short 10-minute recess, after which representatives for the victim may address the board for 20 minutes. On behalf of the victim, Mr. Barry Van Treese, we have been notified that Mrs. Donna Van Treese, Ms. Bridget Van Treese, Mr. Derek Van Treese by Zoom will be the victim's representative spokespersons. If there is sufficient time, we may also hear from Ms. Alana Van Treese Mileto and Ken Van Treese. They will also be joined by several other members of the family, both in person and via Zoom. At the conclusion of the victim's representative's presentation, the board will ask any questions they may have. Following the victim's representative presentation, the board will recognize legal representatives for the state and Mr. Glossip for their respective summations and rebuttals if time has been reserved. And finally, Mr. Glossip will be recognized for 20 minutes to address the board. There is a digital timer displayed at the front of the room so that the speakers may keep track of their time. Only those speakers recognized by the chair will be allowed to speak. And we ask that the rest of the room remain seated and quiet out of respect for today's participants and these proceedings. We will now begin the hearing, and the chair recognizes Mr. Glopp's counsel, Mr. Don Knight, for 40 minutes. Before we start the timer, Mr. Knight, will you please introduce those who, in addition to yourself, will be speaking today?
Yes, thank you, Mr. Chairman. My co-counsel, Amy Knight, will be speaking today. Mary Wright will be speaking today. Representative Kevin McDougall will be speaking today. Representative Justin Humphrey will be speaking today. Justin Jackson will be speaking today, and Leah Glossip will be speaking today.
Thank you. Will you be reserving any of your time for rebuttal?
5 minutes, sir. Thank you.
Thank you. I remind you that it's up to you to manage the time allotted to you for your presentation.
I understand that. Thank you.
Thank you. Whenever you're ready, please go ahead and begin your presentation.
Thank you so much. Before I begin my presentation, just for the record, I want to lodge an objection to the fact that there are only 4 members here. I understand that there was a recusal of 1 member, but the Title 515 of the Oklahoma Administrative Code does require that the board consists of 5 members. So I just, for the record, wish to lodge that argument or that objection at this point.
Your objection is noted. Thank you.
Thank you so much. Members of the Pardon and Parole Board, Attorney General Drummond, members of the Van Treese family. The death penalty is reserved for the worst of the worst. The worst crime committed by the worst offender. It should never be carried out against someone like Rich Glossip, who does not fit that category. A brief account of his background may help explain why. Rich was born into a difficult family. There were 16 brothers and sisters, and a mother and father who struggled with alcohol issues and finding time to take care of their children. One poignant story sums this up. At age 14, Rich left home, and about 2 weeks later, one of his sisters saw him sleeping on a park bench before school. She approached him and she said, "Rich, what are you doing here?" And he said, "I left home for good." And she said, "No one noticed." While many of his brothers and sisters struggled with criminal and drug and alcohol problems, Rich did not. Instead, he used their struggles as an example of what he did not want to become. And developed an ethic of hard work. He dropped out of school at age 14, and with the help of a firefighter, can we stop the?
Yes, if you'd, Paul, thank you.
All right.
I apologize for the technical difficulties. Mr. Knight, would you please speak into your microphone to see if we've resolved the issue?
Testing, 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 testing.
More
Testing,
testing.
testing.
The speakers are turned in this way. They need to be turned on. Yes.
He thinks the speakers, they're turned.
Turn the speakers a little further in that direction. I think that will resolve some of the issue. We have stopped the clock, so your time's not being lost, sir.
Thank you so much. I've seen that. Testing, 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 testing. Hello? Testing.
More testing.
Testing, testing. Ding.
Count to 5.
Testing, testing.
One more.
Testing, testing. Testing, testing. You want me to be on it, right like that? Testing, testing. Testing, testing, testing. Testing. Testing, testing. Testing. Testing, 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 testing. Testing. Testing, testing. We're good? About that close to the microphone?
Mr. Knight,
better?
if you would prefer to start your presentation over from the beginning, we will reset the clock and give you that opportunity.
That'd be fine, thank
All
you.
right, thank you. Mr. Romero, would you reset the clock to 35 minutes, please? Thank you. Please, sir, go ahead, and I apologize for the.
Thank you so much. Once again, I will start by saying that the death penalty is reserved for the worst of the worst. The worst crime committed by the worst offender. It should never be carried out against someone like Rich Glossip, who does not fit that category. A brief account of his background will help explain why. Rich was born into a difficult family. There were 16 brothers and sisters, and a mother and father who struggled with drug and alcohol issues and in finding time to care for their kids. There's one poignant story that sort of sums this up. At age 14, Rich left home, and about 2 weeks later, one of his sisters found him sleeping on a park bench before school. She approached him and said, "Rich, why are you here?" He said, "I left home 2 weeks ago. I'm not coming back." And she said, "No one noticed." While many of his brothers and sisters struggled with drug and alcohol problems, Rich did not. Instead, he used their struggles as an example of what he did not want to become and developed an ethic of hard work. He dropped out of school at age 14 and with the help of a firefighter turned father figure, he started working minimum wage type jobs. And this hard work led to some advancement. He eventually became a manager at Domino's Pizza and later a manager for low rent motels, such as the Best Budget Inn. Rich never needed much in the way of nice things or places to live. Anything was a step up from a home so chaotic, no one even noticed he was gone. Rich was happy with his situation while working for Barry Van Treese in 1997. At that time, a roof over his head and enough money to buy the small things that made his life worth living. That may not seem like much, but for a guy with a 7th grade education and all those siblings were having so many problems, it was pretty good. The idea that he aspired to take over the Best Budget Inn for himself came only from Justin Sneed, a man who now everyone, even the state, admits is a liar. At the time of this incident, Rich Glossip was 34 years old. All of us here who are in the criminal justice system know our experience teaches us that people rarely begin a life of crime at 34. Most true criminals start young and begin to amass a criminal record as a juvenile. Justin Sneed is a good example of this. He was only 19 when he murdered Barry Van Treese, and he had already been in trouble for things like burglary, making a bomb threat at his school, and threatening to kill his middle school teacher. The worst thing on Rich Glossip's record? A traffic ticket. In fact, Rich Glossip continued living a crime-free life, supporting himself with simple, hard work through his 20s and into his 30s. This lack of any criminal history as an adult says a lot about who he really is. Logic tells us that if Rich had any criminal leanings, we would have seen some evidence of that over these adult years. People generally don't become deceitful, violent criminals overnight in their mid-30s. The objective truth is that Rich Glossip, a guy who came from so little, is the kind of person that we all want people who struggle to become. Someone who can pull themselves up by the bootstraps and make something of their lives. He did that through honest hard work and tenacity. The jury in Rich's trial apparently took this lack of any criminal history seriously because when given a chance at his sentencing to find that he posed a threat of violence in the future, the jury found that he posed no such threat. And they were right. The prison records you see in your job with the board all the time give you all insight into how stressful prison life can be. Men who are sentenced to long prison terms get into fights and commit other acts of violence all the time, but not Rich Glossip. In 26 years, he has but just one violation of the prison rules, and that's for possessing a charger cord. This is truly remarkable. Rich Glossip is now 60 years old. He has followed the rules and been safely housed since 1997 and would continue to be if you recommend clemency today. His record while in custody is proof of that. As the jury found, he is truly no danger to anyone. Everything I've just said about Rich Glossip is undisputed, and itself should be enough reason for this board to recommend clemency. Entirely independent, and aside from the tremendous doubt that exists that Rich Glossip is actually guilty of first-degree murder. But when you add this huge cloud of doubt over his guilt to Rich Glossip's good behavior throughout his life, the idea that he must be executed for any reason becomes unsupportable. I'm going to turn this over to my associate, who will discuss more about who Rich Glossip is before we bring in some other voices. Thank you.
Good morning. My name is Amy Knight, not related to Donald Knight. I am also an attorney for Mr. Glossip. We realize that because Mr. Glossip has always maintained his innocence, you may expect him to be able to provide a full explanation of all of his actions from those days in January of 1997. That is not something this man has ever been equipped to do, and certainly not now, 25 years later. As you may recall from our submission, his IQ is at best 78, which is borderline disabled. And the experts tell us that his impairments are magnified in stressful situations. These problems are not immediately obvious when you talk with Rich, because his verbal skills far outpace his cognitive abilities. He's a good talker, but that doesn't mean he understands everything that is going on. This isn't something that we, his lawyers, came up with. This comes from the neuropsychiatrist who examined Rich, Dr. Woods, whose report is in our packet, starting at page 82 of the appendix. Dr. Woods says, quote, individuals with significant impairments are often aware of their limitations in this way and use what strengths they possess to attempt to hide their impairments. Common strategies include simply pretending to understand when they do not, speaking with false confidence, and heavily relying on others, both directly and indirectly. Again, this is coming from Dr. Woods. Mr. Glossip, quote, has been able to draw on his relative strengths in the verbal realm to convey a false sense of capability and, at times, confidence. Often we judge people by their verbal skills, which are not a bellwether of cognitive skills. So while he sounds confident, with his impairments, Rich did not fully understand what was happening, even at the time in 1997. And since then, he has heard so many different accounts from so many different people that it's hard for him to know what he remembers firsthand anymore. It is undisputed that early on, his girlfriend, Deanna, was telling him not Sneed or Vantrease. His limitations make him more susceptible to this kind of direction. Cliff Everhart, a convicted liar, told the first officer on the scene, Tim Brown, that Rich had given him inconsistent accounts. And Brown and Everhart then told Rich he had to be lying. Rich was then interrogated twice by two detectives highly skilled at extracting statements from people. Got in his face, they told him they knew he was lying, and they tried to trick him with a fake polygraph test. It's pretty clear now there's no evidence of a real polygraph ever being given. Rich's first attorney who discussed the case with him when it was relatively recent was mentally ill. He has since been hospitalized and disbarred. We don't know exactly what he said, but the odds are it was incoherent. Jackie Williams, the motel's maid, told police one thing and told the jury something different. Justin Sneed's testimony about that day did not match hers or the desk clerk, Billy Hooper's. Rich heard all of this testimony in 1997 and in 2004, as well as two different narratives from the two different prosecutors who tried the case. And this guy, according to Dr. Woods, has, quote, serious limitations in integrating multiple inputs, low capacity for problem solving, and understanding the big picture. As the experts told us, Rich sometimes speaks with false confidence as a coping mechanism. Under pressure, he consistently looks to others. Here, those others have presented an irresolvable, conflicting mess. And at this point, whatever clarity Rich may ever have had is forever tainted by all that has come between. Please bear that in mind when speaking with him later this morning. Thank you.
And I'll turn it over to Representative McDougall.
To the Pardon and Parole Board, I want to say thank you for what you do. The weight of these decisions I know you don't take lightly, and they are truly life and death decisions. They also determine right and wrong. Right and wrong are exactly the reason I, as a state representative, knew when this case came across my desk and seemed to be ignored by appeals courts that I had to get involved. I had to learn more. To the Van Treese family, I am truly sorry for your loss of your loved one, and I'm sorry that for more than 25 years this case has dragged on. I can only imagine the pain and anger it has caused you and your family, and for that I am truly sorry. Over 4 years ago, a friend of mine, which you'll hear from a little later, told me that he thought there was somebody in Oklahoma death row that could be innocent. I didn't believe him, but I told him I'd look into it. I watched Killing Richard Glossip, a series that told about the case of Richard Glossip. I did not walk away from the series saying he was innocent, but I did walk away saying if even 10% of this is true, it is possible that we have somebody in Oklahoma on death row that could be innocent. I contacted the AG's office, which at that time was Mike Hunter and his staff, and told them I wanted to see any evidence they had that proved beyond a doubt that Richard Glossip was guilty. I also contacted Don Knight, the attorney for Richard Glossip, and set up a meeting with him asking for anything he could show me that proved he was innocent, or at least not deserving of death. After listening to both sides, I was still in a quandary because the AG's office said there were 2 jury trials, so he was definitely guilty. And Don Knight told me that there were so many issues and that Glossip was innocent. The only way I knew to handle the issue was to get a third party to investigate because both sides thought they were 100% right. I put together a small ad hoc committee, including senators and House members, in order to find a third party that was truly not biased to investigate the Richard Glossip case. After a number of online and phone requests, I came in contact with Reed Smith, who partnered with Jackson Walker and Crow and Dunleavy, and they agreed to take on the investigation pro bono. Reed Smith dedicated 30 attorneys and over 3,000 hours of time investigating this case. They took over a year of their time and they published 5 reports. I told the third-party investigators, Reed Smith, from the very beginning that they were to start with fresh eyes. I gave them no predetermined outcome or mandate except to find out what happened and go where the facts lead. If he comes up guilty, I want it in the report. If he comes up innocent, I want it in the report. I simply want them to find the truth in this case. I did not want the bias of the defense or the prosecution to be involved. The investigation came back with a 350-page report. The investigation reached out to both the state and defense, DA's office, AG's office, interviewed over 40 witnesses, including Glossip, Sneed, the police officers, the trial witnesses, new witnesses that had never been spoken to. They got documents from multiple state agencies and uncovered evidence not known until 2022 and 2023. When reading their findings, I was sickened that something like this could happen in the state of Oklahoma. Their investigation concluded that based on the complete record, old and new evidence, no reasonable jury hearing it all would have convicted Glossip of murder for hire and sentenced him to death. So what brought them to this conclusion? What did Reed Smith find? We found that the state destroyed a box of evidence with 10 items in it. The box included items such as tape, shower curtains, financial records, DNA evidence. If the defense would have destroyed that box of evidence, there would have been charges brought against them. But the state seemingly got away with it. The state also misplaced a video that was turned into evidence, which the defense to this day still has not seen. The state had letters where the murderer, Justin Sneed, actually used the word recant, wanting to change his testimony against Richard Glossip. The court said he really didn't mean recant. How does the court know that? How does anybody know that? He used those words in the letters. How do you know that without going to another hearing and asking questions? There was evidence found that the state asked for Sneed to change his testimony about whether or not he used a knife in the murder. His first testimony was that he never used a knife in the murder. after the prosecution asked for the Snead team to change his testimony, he did and said he just forgot. He did use a knife. A key witness for the state, Cliff Everhart, was actually thrown in jail for perjury in another case. Yet he's a key witness on this case. And now with new evidence, we know that the other key witness, the actual murderer, is the one that they use to point the finger at Richard Glossip. When the new AG, Gettner Drummond, came into office with the idea of transparency and justice, he turned over a box of evidence to the investigators that had found documents that included Brady violations. We had asked for those boxes to be turned over the two previous attorney generals, and they refused. Justice Snead never mentioned the name Richard Glossip, not one time, until the investigators told him, you know that Richard Glossip's throwing you under the bus. He is the one putting it on you the worst. We know you did not commit this murder on your own. Who helped you? The investigators mentioned Richard Glossip's name 6 times before they asked Justin Snead who helped him, and he mentioned it was Richard Glossip. One of the affidavits recorded that Snead told a fellow prisoner that he thought Richard Glossip was a snitch because the investigators laid it out that way. And so he mentioned he wanted to get him back by mentioning his name. What did Justin Snead, the murderer, get? He received a deal from the state that took him off of death row and gave him life in prison. The jury never saw the video of the 2 investigators coercing the witness. As a state, we are better than that. The Oklahoma standard should be for justice. We should be tough on crime, but we have to be just. Our death row system must be pure. We have to know when we are putting people to death, they're deserving and that the highest bar of guilt should be met. The Oklahoma standard should be to hold ourselves accountable and be willing to admit our mistakes. The people of Oklahoma want to trust our legal system, and they will have more trust in a system that admits mistakes instead of acting like they never happened. I'm asking all of you to see this case for what it is. All I was asking for all along was a new trial. Let a new jury decide after they have seen all the evidence. Personally, I believe he is innocent of the charge of murder. I believe there are too many mistakes in this case, and it does not meet the high bar required to be put to death. I don't see how anything other than a request for clemency can be recommended. Since the Court of Criminal Appeals refused to stand with the state and the defense, who happen to agree today, to correct the wrongs in this case, no matter how uncomfortable it may be, please vote for clemency and ensure the blood of this problematic case is not on the hands of Oklahomans.
My name is Representative J.J. Humphrey. I want to thank you for your service. I know this is a really hard job, as well as say it's an honor to get to speak in such an important case. I am a 35-year law enforcement officer. I actually was a probation officer, and I have made many reports and investigations to this board, and so I understand your jobs very well. For 7 years, I've been a representative, public safety chairman, and chairman of criminal justice and corrections. I've taken an oath to carry out justice. This is an oath that is extremely important, and I believe that y'all have taken such an oath as well. I made that oath to God, and I made it to the people of Oklahoma, and I'm here to carry out that oath. When I was first contacted by a friend to look at this case, I was extremely reluctant. Being an officer of the court, a law enforcement officer, I explained that there was so many systems that this person had had and so many opportunities that there was no way that I believed that something could slip through the cracks. And I truly believe that. But because of my friendship, I looked into this case. And here's what began to happen. It wasn't the evidence that I saw, it was the lack of evidence. And we had, as the chairman of public safety, we went to the former AG and the former DA. We had a hearing to try to obtain evidence. And in that hearing, I tried to persuade them to say, you know, if you're going to execute somebody, you should have an impeccable case. You should not be scared to throw out the evidence and show not only us, but the people of Oklahoma that we are right in carrying this death penalty out, the highest penalty that can be pulled out. We should be able to see as people of the state of Oklahoma that we have a good and correct law enforcement court system. They refuse to provide any, not one shred of evidence. I still remain skeptical that we had a great court system and that this couldn't happen until we had an independent investigator, Reed Smith, which you've already heard. Here's the thing, as a law enforcement officer, that not only was I shocked, but I am appalled, I'm sickened by the fact that an investigator, the fact that a prosecutor would order evidence be destroyed. What purpose? Why would you destroy evidence in the life in such a critical case? I can think of no reason. It's illegal, it's wrong, it's unjust. That one evidence by itself, it demands justice, demands we overturn. But they violated the rule of sequester in that they provided information that one witness made to another. Yes, it was their witness. Yes, they could talk to him, but they can't provide what another witness said. They violated that court order. Not only did they violate the court order, but they told that witness to change his testimony and wrote what they wanted him to say because it didn't match. His testimony didn't match what the medical examiner said. Now, I'm an officer of the court. That's not only wrong, but it's a felony. It's called witness tampering. And the position they held during that, I honestly think it was intimidation of witness, both felonies, criminal. But at the most, it would warrant a mistrial. Not only did they manufacture evidence and witness and tear up evidence and destroy evidence, but when they got found out, when the defense said, hey, that should be a mistrial because he changed his sworn testimony, then the prosecution jumped up and said, well, we're just hearing this at the same time, so we're all on playing field, so it shouldn't be a mistrial. Wrong, because they're the ones who told them to say it, so they committed perjury. These acts I take seriously. As an officer of the court, I would never do any of these acts, and they warrant that we should declare a mistrial. We presented this to our new AG, and he actually spoke with me and said, you know what, y'all had jury independent, but I want a person who represents
Jennifer, can you hear us now?
Yes, ma'am, I can hear you guys.
to go?
Yes, sir.
Representative Humphrey, I apologize. We're ready to continue. Please go ahead.
Thank you. I just want to summarize that there's a statement lawyers use. It's called fruit of the poisonous tree. This case was corrupt from the word go. This case was corrupt, and it is our duty, your duty, my duty to carry out justice. I ask you, vote clemency and carry out justice demands that we vote clemency. Thank you very much for your time.
Good morning. My name is Justin Jackson. I'm from the Clayton area of southeastern Oklahoma, and I was first introduced to this case by watching the documentary Killing Richard Glossip in 2017. I'm in full support of capital punishment, but we as Oklahomans must be absolutely sure there are zero doubts that the convicted is 100% guilty. After watching said documentary, I was left with many questions and concerns about this case. In 2018, I was heavily involved in several political races, including Kevin Stitt's campaign for governor. Days after attending the inauguration ball, I woke up with this feeling of urgency to get in contact with Glossip's legal team. I soon found Don Knight's number and remembered pausing briefly before dialing, for at that time, I was taking care of my mother who was gravely ill with cancer. And being an only child, my plate was full. But I could not ignore what I believed to be the tug of God to get involved, and I reached out to Knight's office. From that first call until now, 5 years later, myself and several conservative friends, including Representative McDougal and Humphrey, have been in search for truth and justice in this case. In our quest, we have found the overwhelming evidence that supports Richard Glossip's innocence. Through this journey, I've grown to know Rich as a friend and a brother in Christ. I've spent countless hours visiting with him in prison and talking on the phone. Rich has never wavered once in his claim of innocence. When my mom was in her final days, Rich painted this picture for her and wanted me to convey that for him, the hummingbird that you see represented freedom from his prison cell on death row. But for my mom, he wanted to view the hummingbird as freedom from her pain and suffering. My mother, Linda Jackson, died in the early morning hours of May 20th, 2020. Rich had no way of knowing of my mom's passing, but by happenstance, he called me later that morning, and he spent the next 30 minutes consoling me. Rich knew my pain, for when his own mother died, he heard her last words over a prison phone, yet had no one there to console him. After 26 years of incarceration, 9 execution dates, and 3 last meals, it was that one call from his dying mother that nearly broke Rich. I respectfully ask each of you to not ignore the facts and evidence in this case. Look deep into your conscience, and most importantly, your heart, and give Richard Glossip the clemency he deserves. I want to thank you for your time and service to the great state of Oklahoma. Thank you again.
Pardon and parole board members, my name is Leah Glossip, and I'm Richard's wife. I would like to take a moment to speak about my husband. Richard is a son, a brother, a father, a friend to many, and he's my partner and he's my best friend. The love we have and our shared faith is what has gotten us through all that we have faced. It is impossible for anyone, including myself, to fathom the gravity of what Richard has lost, having lost 26 years of his life, along with essentially everyone and everything he knew in it. Today, he is now on the brink of his 9th execution date, all for a crime that he did not commit. This ordeal has been absolutely psychologically terrorizing. Last week, we again sat across the table from each other, hand in hand, the shackles cutting into his wrists, while we again filled out the paperwork describing how my husband will be put to death, who will be in the room to watch him die, what his final meal will be, what our funeral arrangements will be. And I cannot even begin to express to you how agonizing of an experience that is to have to do with the one you love. Yet Richard is still the most resilient person I know, with such a deep, unwavering faith. Anyone who knows Richard, our family, our friends, corrections officers, members of our church, all can speak to this, as well as his grace, his spirit, and his heart. Through it all, and despite the weight of our current circumstances, we have a strong marriage. We start and end every day together, navigating daily life like any other married couple. We have dinner together every night over the phone, and we participate in Sunday service at our church every week. Richard is also my biggest supporter as a current student at OCU Law. And while Richard can never get back all that he has lost, we have built a life together, and a life that I prayerfully hope Richard will be finally coming home to. Richard has also experienced profound loss in the 26 years he has been on death row. Before his mother passed away, she had asked him to make a promise that he would never give up. As his wife, I will always be by his side, and I will always help him fulfill that promise to his mother, and I will fight for him no matter what. Just please hear me when I say that I cannot lose him. And while each day right now is an agonizing countdown on my husband's life, and we are deeply grateful for everyone who has fought so hard and taken such courageous stands on this case, it is my sincere hope that the board members here today will come together and recommend clemency for Richard to help right this wrong once and for all. Thank you.
Thank you, members. My name is Mary Wright. Over the last 8 years, I have gotten to know Richard Glossip very well. Sometimes I feel like I know more about him and his life than he does. I first learned about who Rich was according to 38 banker's boxes full of records and transcripts. Since then, I have been to McAllister many times and have spent countless hours with Rich. The man that was portrayed in these trial boxes is not the man that I met, and the person that he was portrayed to be doesn't seem to exist at all. Over the course of our investigation, we spoke to hundreds of people, including Rich's family, his friends, his neighbors, his school teachers, his mentors, and his past employers. Not a single person ever said that he was violent or even unkind. His teachers all said there was no way that he could be a mastermind of anything like this. It is not in his nature. We found no evidence of Rich saying or doing anything to anybody with malice in his heart. I found no trace of the monster that he was made out to be. The word used by most to describe Rich Glossip is gullible. I've seen over the years that Rich has always tried to laugh and make light of impossibly grim circumstances. And for a very long time, I could not understand why. I know now that this is how he copes with these stressful situations. This is who Rich is. He's kind and he smiles and he just tries to do his best. He is that 14-year-old kid that was on the bench. He was in way over his head when something truly horrific had happened, and he was not equipped to handle it. I believe he is a person deserving to live. Thank you.
We deeply appreciate your listening to the witnesses that we have produced for Mr. Glossip today. And I know you'll have a chance to talk to Rich a little bit later today. We express our deep sympathies to the Van Treese family for what happened to Barry. That should never have happened to anyone. Justin Sneed murdered Barry Van Treese. Rich Glossip didn't. You heard the criminal history that Rich does not have. You heard the statements that everyone here says about Rich Glossip. There's no reason for us to believe that all of a sudden, in one moment, he became something that he never was in 60 years of his life and decided to do this. Is that reasonable? Or is it more reasonable to believe that the only person accusing him of that Justin Sneed is now called a known liar, even by the state. Of course, Justin Sneed is a liar. And Rich Glossip has now paid with 26 years of his life. We urge you, please, to consider clemency, because that's the way the state of Oklahoma has devised to remedy an unjust and excessive sentence. Thank you so much.
Thank you, Mr. Knight, and to all of those that you have brought as part of your team. We appreciate everything you've shared with us. Thank you very much. The board will now hear from the state of Oklahoma, and the chair recognizes Attorney General Gentner Drummond for 40 minutes. Before we start, Mr. Attorney General, will you please introduce others who will be speaking along with you today?
I would like to reserve 3 minutes at the end. Also presenting will be at the request of the legislature, Christina Vitale, and then followed by her, the independent counsel engaged by my office, Rex Duncan.
Thank you, sir. You may begin whenever you're prepared.
Thank you. May it please this honorable board, Mr. Chairman, distinguished members of the board, and guests attending both in person and online. I would like to also recognize and acknowledge the several members of the Van Treese family who are here with us and are also participating online. And I know that this has been an extremely difficult process for the family to endure. And it has been my absolute privilege and honor to visit with many of them over the course of my last 104 days. And it is my honor to serve and assist them through our victim service unit, principally Karen Cunningham and her staff. I want to acknowledge how unusual it is for the state to support a clemency application of a death row inmate. I'm not aware of any time in our history that an attorney general has appeared before this board and argued for clemency. I'm also not aware of any time in the history of Oklahoma when justice would require it. Ultimately, that is why we are here. Everyone in this room, we are here to see that justice is done. We may have different opinions on what justice looks like in this case, and I fully respect those differences. But in the end, that's what we must have. For me, as the state's chief law enforcement officer, I must be primarily considering what justice is for the state of Oklahoma. And that is what has compelled me to devote hours, countless hours of my time examining the facts in this case. And it is that sense of justice that has compelled me to release materials to the defense team that have been long withheld. I was concerned enough by the research that I had observed that I should retain an independent counsel to conduct a comprehensive review. Former District Attorney Rex Duncan is here today, and he will speak to you briefly about his report, and which I believe has already been provided to you. His review was de novo. He did not pretend to be a reviewer post-trial, but instead he looked at the facts as they were presented with the fresh eyes, and his report will indicate that. Before you hear from him, you will hear from Christina Vitale, who led the independent investigation on behalf of the Reed Smith Law Firm. And as you have heard from Representative McDougal, this firm was engaged by concerned Oklahoma legislators who are passionate about ensuring our criminal justice system generates the right outcome. It is at their formal request that I've yielded time to their independent investigator. And finally, after they have presented to you a good deal of information to consider, you'll hear from me again in closing. Before I turn it over to Christina, I would like to thank all of you once again for your service to Oklahoma. The decisions that you make are always difficult and always weighty. I respect the informed and educated approach you take. I respect the role that you play in our criminal justice process. And above all, I believe that each of you will make your decision based on what you believe is right and just, and justice will prevail for all involved. Thank you. I now yield the floor to Christina.
Thank you, sir.
Chairman, would you mind stopping the clock so I can set up and hook in?
Yes, we will.
Thank you so much. We have hard copies of the PowerPoint if any of you would like them.
Please, if you would distribute them. You have sufficient copies to give one to our legal counsel. Mr. Constantine. Ms. Vitale, I'm assuming you're going to do a PowerPoint presentation.
Yes,
Would you please test that before we turn the clock on? Make sure it's working, please.
yes, thank
Thank
you.
you.
How do I connect my screen to the Zoom link? I apologize.
Are you logged into Zoom
Yes,
for this meeting?
I believe so. Hold on. Yes, I'm seeing myself on the screen.
What name are you logged in on?
C. Vitale. Thank you. I'm ready.
Okay, great. Please start the clock. Go ahead.
My name is Christina Vitale with Jackson Walker Law Firm. I co-led the independent investigation that was requested by the Oklahoma legislators in 2022, along with my colleagues from Reed Smith and my Oklahoma partners, Crow and Dunleavy, who are all here today. We are grateful to Attorney General Drummond for allowing us the opportunity to speak to you all today and for his judgment on this case. Our mandate from the legislators was singular: follow the facts wherever they may lead. In addition to the facts, we were governed and guided by the rule of law. In death penalty cases, the Supreme Court has required the highest standard of reliability. Now, we recognize you are not a court of law and that your analysis is not a legal one, but a question of clemency. As part of your analysis, you consider multiple factors, one of which is evidence that was not available to the court or the jury at the time of trial. And this factor resonates louder than the other ones, because after a year-long investigation, what we now know is that there was a significant amount of material evidence that was not presented to the jury, was not considered before the jury rendered its verdict and the ultimate death sentence. I would like to highlight today for your consideration the salient findings of our investigation, the evidence that the jury was not presented with at the 2004 trial. It's important to keep in mind here that the sole death penalty aggravator was murder for remuneration, the evidence of which only came from Justin Sneed. One of the prosecutors has described it as this, quote, "The specifics about the murder plot came from Mr. Sneed entirely." And yet the jury was not aware of several facts. First, Sneed discussed, quote, recanting his testimony and wanting to break his plea deal multiple times before and after the trial. The jury was not aware of that. Second, Sneed had been diagnosed by a psychiatrist in 1997 with a serious mental health disorder. The jury did not consider the impacts of that on his credibility or memory recall. The new evidence reveals that the state was aware that he had seen a doctor and that they did not disclose this critical fact. During the state's examination of Justin Sneed, the state failed to correct the record so that the jury would know in fact that Sneed had seen a psychiatrist. And after an evaluation that had diagnosed him with this serious mental disorder, that's why they prescribed lithium to him. The jury was not informed that the day before Sneed testified, the state supplied him information about other witness testimony, including the medical examiner's testimony, through his attorney, also a state's witness, and that Sneed changed his testimony on one of the points that was specifically literally reiterated in the memo that was sent from the prosecutor to Sneed's attorney. And she described this topic that Sneed changed his testimony on as, quote, the biggest problem. The jury did not know that the state destroyed evidence before the 2004 trial. Finally, I would like you to consider the impact of this withheld information on the appeals process. Now, you might be wondering, what is there for you to consider, because the Court of Appeals has already heard all of this, with most recently a decision coming out last week. But the court explicitly stated in that opinion that it is limited in its review by the Post-Conviction Procedure Act, excuse me. And you are an independent body that is not governed by that act. You operate under a different statute and a different set of rules. And the question before you is, again, not legal, like it was before the court, but a separate and distinct review asking whether clemency should be granted. And it's important to remember that clemency is rooted in mercy and fairness and grace. For context, when looking at the new evidence, it is important to consider the state's case that was presented to the jury. And I think we are guided by the statements of the judges and prosecutors most familiar with the record. And I've provided to you a few examples of how this case was described by the judges that reviewed this record and the prosecutors that prosecuted the case. And the common theme from all of these observations is that the murder case against Glossip rose and fell with the testimony of Justin Sneed. There is no dispute between the parties of record that Sneed was the key witness. So it follows that the jury's assessment and determination of Sneed's credibility was critical to Glossip's conviction and death penalty conviction. Again, the aggravator here is murder for remuneration. And yet the jury was never aware that behind the scenes, Sneed was asking about recanting his testimony and wanting to break his deal. The Court of Criminal Appeals concluded that, quote, there is no evidence that Sneed had any desire to recant or change his testimony. But I'd like for you to look at the letter that was written by Sneed to his attorney in May 2003 that states, "Do I have the choice of recanting my testimony at any time during life?" Now, the way we came about this is because the chief public defender, upon review of his files and pursuant to the Code of Professional Responsibilities and the pending threat of death, felt compelled to produce a very narrow set of redacted documents to us that contained Snead's statements about recanting his testimony. Please consider his concerns and the extraordinary step that he took here. Even one of the prosecutors on the case agreed that if somebody told me, Snead told me he's thinking about recanting, of course, that's clearly Brady material. And he outlined what his concerns would be, including the uncertainty of the waffling back and forth and the disingenuous bad faith nature of such actions. In other words, this goes to credibility. It goes to the state's theory of the case. And the letter is supported by other evidence in the record. In fall 2003, there were a series of actions that were taken by the state that are relevant. Soon after the state met with Snead in September 2003, only 6 days later, they added Snead's attorney to the state's witness list. At a hearing, the state explained to the court why Snead's attorney is potentially relevant and added to the state's witness list. The important takeaway for your consideration here was that the state was taking extraordinary measures before the trial, and that these actions, they tend to indicate an awareness of Snead waffling behind the scenes. We now know from his letters that's what he was doing. Snead also confirmed to us in 2022, that the prosecutor was aware before trial that he did not want to testify and he wanted to break his deal in hope of getting a new one. The jury knew none of this. Now, it is true that Snead in 2022 stated that he really didn't mean recant when he wrote recant. He just wanted to break his deal. Two things for you to consider. One, his writings do not say plea. They do not say deal. They do not say agreement. They say recant my testimony. The second was this was not the only time that we learned that he talked about this. In 2007, years after he pled guilty, after he had testified, Snead again writes to his attorney stating, "There are a lot of things right now that are eating at me, some things that I need to clean up." He then says if he can't get a hold of his attorney, he's going to reach out to Glossip's counsel or the DA's office. It was a mistake. The second letter tends to reiterate that Snead was again having second thoughts. Please consider this and that the jury did not know this. The second fact that was not disclosed or available to the jury relates to impeachment evidence of Snead that was withheld. Now, this did not come to light until Attorney General Drummond authorized release of a box 8 from the DA's case file in 2023. This evidence was that Snead saw a psychiatrist, was diagnosed with bipolar disorder, and was prescribed lithium because of that serious mental health issue. In box 8 were interview notes taken by the prosecutor when they met with Justin Snead in October 2003. They were handwritten notes memorializing facts and what Snead was saying to them. In one of the pages, the prosecutor documented, quote, "on lithium," and quote, "Dr. Trumpet." Now it is that red box, the second one, Dr. Trumpet, in combination with lithium, that is the critical component here. Based on that reference, Dr. Trumpet, we were able to discover in less than half a day, there exists a psychiatrist named Dr. Trumpka. And this psychiatrist, Dr. Trumpka, is still a Department of Corrections psychiatrist today. And in 1997 and 1998, he was the sole psychiatrist at the Oklahoma County Jail. Without these data points, lithium and Dr. Trumpet, we would not have been able to determine that Snead had seen a psychiatrist in 1997, that he was placed on lithium due to a serious mental health diagnosis. Now, Dr. Edith King is a psychologist you may have heard of, and she evaluated Sneed in 1997, but for a competency evaluation to see if he could stand trial or help his attorney. She is a psychologist, and I say that not to be demeaning, but it's a critical distinction here. A psychologist is a PhD, as you know, not an MD, and cannot prescribe lithium. In her report, she was relaying what Justin Sneed told her, and he told her that he was on lithium for a tooth pulling. The issue is further compounded by the third fact that was not disclosed to the jury. Sneed testified falsely, and the state did not get up and correct the record for the jury to know what actually was true. In the state's direct examination of Sneed, the prosecutor elicited testimony for the prescription medication that Sneed was on after he was arrested. Now, some of the attorneys on the board might appreciate this. We're all taught in trial, if you're worried about something, you bring it up on direct so that you can deal with it head on. Maybe that's what was happening here. But what's relevant for your review is what the jury heard. And the jury heard, when I was arrested, I asked for some Sudafed because I had a cold. But then shortly after that, somehow they ended up giving me lithium for some reason. I don't know why. I never seen no psychiatrist or anything. Due to the new evidence from Box 8 of the DA's case file, we now know that testimony is not accurate. Attorney General Drummond's decision in 2023 to release the prosecutor's notes informed us that Sneed had, in fact, mentioned a psychiatrist. Based on the jail records that we obtained and that we have submitted to this board, we now know that Sneed was diagnosed with a serious mental health disorder, bipolar. And because of that diagnosis, not because of a cold, not because of a tooth pulling, that's why he was prescribed lithium. The jury was not permitted the opportunity to have a complete and accurate record on which to weigh this witness's credibility. This key witness that the case rose and fell on. Now, to be clear, the Supreme Court tells us that the district attorney has the responsibility and duty to correct what he or she knows to be false and elicit the truth. But the court goes on to instruct that I think what's really relevant for you all here. It doesn't matter why it happened. It matters that it happened and that the jury was not able to hear this evidence and properly evaluate it before rendering a decision. And the reason this information is so critical to the jury's assessment of Sneed's credibility and to the state's theory of the case is best explained by Dr. Trumpka, a psychiatrist for nearly 30 years, himself. He explains that based on his training and experience, bipolar disorder symptoms can be exacerbated by illicit drug use, like methamphetamine. Recall that on direct examination, Sneed testified that he used marijuana and crank. That's methamphetamine. He also clarified with us in 2022 that he could have very well been using meth in January 1997. If not the first week of January, quote, I was at least experiencing coming off of it. And this is really key because Dr. Trumpka explains that a manic episode could bring on paranoia or potential violence, and the manic episode would last for a few days when the individual was coming off methamphetamine. This goes directly to the state's case, why this murder happened, the credibility of Justin Sneed. The Supreme Court has observed that the jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence. This is exactly the relation of Justin Sneed to Glossip's trial. Recall how Sneed was described by the judges and prosecutors, the principal witness. The murder plot came from Sneed entirely. And remember, the sole aggravator here is murder for remuneration. So does it not follow that information about Sneed's reliability and memory recall were critical for the jury to know and weigh as the fact finder? Is it fair that the jury did not know this critical information about his serious mental health disorder, or that the jury was misled by his testimony? That the record was not corrected with the data points that we now know in 2023 that the prosecutor learned from Sneed in October 2003? For your evaluation, again, it does not matter why it happened. It matters that it happened and it was not available to the jury. Now, the Attorney General answered the questions that I just asked with a resounding yes. And the state in April 2023 confessed error on this point. Please consider this rare and extraordinary act. The fourth fact that was not known until September 2022 also relates to Snead's testimony. The state supplied other witness testimony to Snead the day before he testified. The day before he testified. His testimony on the stand changed on one of those specific points. Now, it's important just for context to remember the purpose of the rule of sequestration, which was invoked in this trial from the beginning. It is to prevent, quote, the tailoring of testimony by one witness to coincide with the testimony of the earlier witnesses and to assist the trier of fact in determining credibility. In September 2022, we discovered for the first time that the state disclosed a memo from the DA's case files, and that memo was written by the prosecutor to Snead's attorney. Remember, she was also a state's witness at this time. And the information in the memo that we've submitted in our packet states explicitly, the first sentence, here are a few items that have been testified to that I needed to discuss with Justin. So that information was intended for Justin before he testified. We know from the substance of this memo that it was written during the 2004 trial because Kayla Persley, for example, only testified once during the 2004 trial. It also contains substantive information, testimony from other witnesses, like a police detective who found the knife and the medical examiner who took the stand the day before Snead testified. For the first time, Snead testified in the 2004 trial that he actually had used the knife during the attack. That was elicited by the state, again, on direct examination. One of the prosecutors described this change as, quote, a night and day difference. And this made a motion for a mistrial after this because it was such a change in testimony and they had not heard it before. The prosecutor informed the court that she did call Snead's attorney, but she stopped there. What she disclosed was not what was communicated in the memo. The other witness testimony, that was not disclosed to the court or the defense. And the jury, and just to give you an example of what wasn't disclosed to the court when this was actually discussed, is the substantive information contained in the red boxes. Now, we've confirmed the handwriting was Snead's attorney. So you see the handwriting on the sides of the memo, that was Snead's attorney. And that tells us that she got the memo and she gave it back to the prosecutor. That's how we found it in the DA's case file decades later. And we elicited the help of a legal ethics expert, OCU Law School Dean Emeritus Lawrence Hellman, to help us navigate this issue. He is here today to answer any of the board's questions. The Court of Criminal Appeals concluded on this topic that there was no evidence that Snead was coached to fabricate his testimony, nor is there evidence that Snead's testimony was tainted. But compare what Snead told police in 1997. He did not use the knife versus what he testified to in the 2004 trial. He did use the knife. Remember the prosecutor's words, night and day difference. The state confessed error to this fact as well in April 2023. Please consider that. Fact 5 that was not known to the jury was that the state destroyed evidence before the 2004 trial. Now, reasonable minds can disagree whether the DA did it or the police did it. But for your inquiry and your consideration, it doesn't matter. It was the state. Now, in the police report that we submitted in our packet, here are the items that were destroyed. And I believe that 7 to 9 are the key ones for your consideration. Remember that the state pursued as the primary motive for the murder for hire that Glossip embezzled $6,100, and because he feared being fired, he orchestrated the murder for hire. That's what the jury was told. We all know to determine whether or not there's embezzlement, you need to do a deep dive accounting and you need the financial records. And remember, this was 1999. Computers and Excel weren't that commonplace. And we know from multiple witnesses that Mr. Van Treese was meticulous in his financial accounting, and he did most of it by hand. He had deposit books and he had receipt books, and they were done by hand. It appears that these financial records that were destroyed were material. The Court of Criminal Appeals procedurally barred this claim. Now, even though you're not making a legal judgment, you are assessing whether clemency is warranted here. And I do think it is worth considering that this issue was evaluated by the court, not on the merits. Please also consider that the defense counsel did not raise this destruction of evidence issue, and it was not because of strategy. This is the affidavit of Janet Chesley Davis, Glossip's appellate attorney. And she says she should have raised the destruction of evidence issue in this direct appeal because it was a clear due process issue. When one of the prosecutors became aware of the destruction of evidence, he stated that it, quote, horrified him. We share his concern, and we ask that you consider this fact. Now, no trial is perfect. We know that. But there comes a point where we have to recognize that the guardrails and the protections built into our system did not function properly. The clemency process is the last corrective measure at this point that the state has before execution. One of the main architects of our legal system, John Adams, once said that representative government and trial by jury are the heart and lungs of liberty. But this vital organ can only function if it is fed oxygen. And we know now that the oxygen, that critical information primarily relating to the state's key witness and the state's theory of the case, was not provided to the jury. So I ask you to consider, how can a trial by this jury have functioned properly under these circumstances? How can we rely on the end product when we know now that the process was flawed? The final item that I would ask you to consider is the impact of the withheld information on the appeals process through the years. The state did not set the record straight until Attorney General Drummond did so in 2023. The Supreme Court, in a 2004 decision, the same year that Glossip was convicted, instructed that, quote, when police or prosecutors conceal significant impeachment material in the state's possession, it is ordinarily incumbent on the state to set the record straight. I will note that the Court of Criminal Appeals in last week's decision commented that the issue of Sneed's mental health disorder and treatment by a psychiatrist could have and should have been raised years earlier. We know there were appeals, but we also know there were problems. For example, please consider in 2015, the defense for Glossip raised in a habeas petition and requested specifically Sneed's jail medical records. Now we know because of HIPAA privacy laws, there's only two ways to get medical records: consent of the person or a court order. Sneed would obviously not give consent, and the defense's request for a court order was denied. But we know now, with the evidence that we have released by Attorney General Drummond, that this line of inquiry was not a fishing expedition, it was highly relevant. The clemency process is a vital part of our system, properly implementing the death penalty. You as the board and the governor are the final double check. And the looming question that you have to reflect on is, are we going to allow an execution to go forward based on this record, the complete record? Former Assistant Matthew Hare, who is here today, said it best when he said, When there are still questions that haven't been answered, we can't go forward with an execution. There's so much evidence that the jury did not hear, so much evidence that we now know. Shouldn't mercy be given when the Attorney General sends a warning that we cannot rely on this trial and asks for clemency? This is such a rare act. It's never been done before in history. And the confession of error by an AG in the last 40 years has only been done one other time. No matter where the blame lies, we should all be uncomfortable with what happened in this death penalty case. You have the constitutional power to correct this unjust and excessive sentence. I thank the Attorney General for raising this warning, and I ask the board to use its authority to heed that warning. And I leave you all with the words of Judge C. God help us if ever in this great country we turn our heads while people who have not had fair trials are executed. Thank you.
Whenever you're ready, please. Thank you.
Thank you, Mr. Chairman and members of the board. My name is Rex Duncan, and my role in this matter is that of independent counsel retained by Attorney General Gentner Drummond. This is a first for me to agree with the defense attorney that their client deserves clemency. And I can see that there's no painless resolution here today. After 600 hours of review in this matter, the bottom line up front, I think Richard Glossip should have his conviction vacated and his case remanded for a new trial. However, since that's not why we're here today, this board should grant clemency. It's my opinion as a former district attorney and a lawyer for 34 years practicing primarily in criminal law cases, Richard Glossip did not receive a fair trial and that the state of Oklahoma cannot stand behind his conviction. Further, the state of Oklahoma cannot stand behind an execution given what has been discovered since January 2023. Every continuing legal education course I've attended since the 1980s placed a premium on ethics. For CLE courses covering topics in criminal law, the Brady case and discovery mandates are almost always discussed. It matters not whether attendees are baby lawyers or senior partners, prosecutors, or public defenders. Fair trials require fair play. Fair play requires compliance with discovery statutes in an actual adversarial proceeding. Discovery is not a game of hide and seek. Brady violations can be unintentional, but even unintentional violations can prevent a fair trial by withholding exculpatory, mitigating, and impeachment evidence. Your discretion is powerful, literally that of life and death. So thank you for accepting your appointment to this board. When I filed my one and only bill of particulars, my discretion as a DA was less powerful than yours here today. In my case, I wanted the jury to consider death as I am an advocate for the death penalty in the worst of the worst cases. Shortly after leaving office, my successor pulled the bill of particulars and allowed that defendant to plead guilty and accept a life without parole. That was his call and proof that new personnel bring their own discretion to the table. When analyzing fair punishment in each case, a DA considers all available facts and admissible evidence. Defense attorneys have much the same experiences and evaluate each case in much the same way. Judges, many of them former prosecutors and defense attorneys, fit the same mold. Justin Sneed killed Barry Van Treese, and Sneed's in prison serving life without parole. If anybody deserves to be on death row, it's Justin Sneed. Richard Glossip has been on death row most of his adult life, has been served his last meal 3 times, and been within minutes of execution. As a former DA, I would consider those facts in determining a fair punishment. The facts of this case always supported a conviction for accessory after the fact, and they still do. The maximum punishment is 45 years, and I believe it's considered a 75% crime when associated with first-degree murder. A life sentence, as you know, is calculated at 45 years and is an 85% crime. A fair punishment for Richard Glossip, given his 3 last meals and good conduct for 26 years and maximum security would be a recommendation for a 45-year sentence for accessory. There's no scenario in which I can be convinced a death sentence is remotely appropriate given all of these facts. There are monsters among us, and there are monsters not yet born who will one day commit unspeakable and heinous crimes against innocent Oklahomans. I hope the death penalty is available to DAs in those cases. However, what the voters give, the voters can take away. But if the state of Oklahoma remains in the business of killing monsters, we must be righteous about every aspect of that process. We must carry out righteous killings. Justification must be so far above reproach that only the anti-death penalty advocates could criticize their result. To be righteous, the process must be right, it must be fair, and held to the highest scrutiny. This case doesn't clear those hurdles, in my opinion, given what was found in box 8. And it's never too late to do the right thing prior to an execution. Finality, in any case, if such is possible, should be superseded by new evidence. The state of Oklahoma is telling you it suffers no harm by seeking clemency for Richard Glossip, and my independent review to include newly discovered box 8 materials convinced me the death penalty is wholly inappropriate in this case. I don't stand to gain anything by the outcome of this matter. I'm just an independent lawyer who wants to see a state do the right thing, and in the course of doing so, demonstrate mercy. The state of Oklahoma can extract its pound of flesh from Richard Glossip, but I believe it has already extracted 3 pounds. Today is the next best day for the state of Oklahoma to demonstrate grace and mercy. Thank you for listening.
Thank you, sir. Does the board have any questions for the representatives from the state of Oklahoma? Mr. Drummond, I want to clarify, did you want to say something in the remaining time, or you want to wait till you're still? Okay, thank you very much. Okay, and Mr. Knight, just so you know, I did survey the board if they had any questions for you, and they did not either. So I didn't verbalize that before, but I wanted you to know that. Thank you. Okay. It is now 11 a.m. and the board will take a short 10-minute break, and that will allow time for the victim's representatives to come forward and be seated. We are in recess. a.m. and this hearing is out of recess. The chair recognizes Mrs. Donna Van Treese as the spokesperson for the representatives of the victim and the others that you have brought with you. And you will have 20 minutes, and I would ask you to try and manage that time amongst those who wish to speak. And if we have sufficient time, then Alana and Ken can also speak to us as well. We are aware that there are a significant number of members of your family here. We thank you for being here this morning. We know this is a very difficult time for you. We just want you to know that we respect you for coming and participating in this hearing this morning. So whenever you're ready, please begin.
Good morning, ladies and gentlemen. I appreciate you having given us the opportunity to speak here. We feel like we need to be represented and stood by as a family, and to be able to tell you our side of this and what we have gone through personally, and how this has, the entire event is constantly, it feels like we have let a wound heal and the scab's been torn off again multiple times over the years. So my name is Donna Van Treese. I'm the widow of Barry Van Treese. We had been married for 18 years at the time of his untimely death, and tragic at the age of 54 years old on January the 7th, 1997. That's the day my entire world shattered. I was only 38 years old at the time. I had 5 children at home. They were 5, 7, 9, 11, and 16. Barry had 2 children from a previous marriage. They were 31 and 27. Barry also had 4 grandchildren at the time. They were very young at the time of his death. Now we have 13 grandchildren and 3 great-grandchildren that has missed his love and devotion and silly songs that he sang to all of us. Family was very important to Barry, and we have greatly missed his presence in all our lives. Barry was the kind of man that made you proud to have known him. He would help anyone in need. Personally experienced this over the years of business we were in. People would come, not have a place to eat, not have a place to stay. When he worked at Boulder Bank in downtown Tulsa, he made arrangements with a cafe there close by and took up donations to feed those homeless men and women that were there, and did it with very influential customers he had at the bank would come in, and the oil moguls and everything that were in Tulsa at the time. And he orchestrated things like this to help. He helped with the Boy Scouts. He helped with everything that we were involved in with our children. The loss of Barry has made a huge impact on our family. His loss was felt most keenly by every graduation, wedding, birth, and death of our family members. One of his daughters, his oldest daughter, has passed away with cancer since this has all happened. She did not get to see justice on her time here on earth. Every milestone of our lives have been affected by this tragic loss. The impact of his death has been huge. We have struggled to keep on going. I personally have experienced sleepless nights, wondering how I was going to feed our children with our main breadwinner gone, how I was going to keep a roof over our heads, all because of the selfish acts of others. No one should have to tell their children that their father was never coming home. Explaining why he's lying in a casket and not moving. Explaining that Barry's body is just a shell. That the funny, loving, silly song-making dad was his soul. and that his soul is no longer with us. My son Joe was 5 years old at the time of Barry's murder, said, they used to go to Sutherland's and get peanuts. And that was their thing after kindergarten. They would break up in the shell. So Joe says, life is kind of like a peanut. When our souls have outgrown our shells, we no longer need our shells or our earthly body. So out of the mouths of babes comes what his reality was at the time. That's how he dealt with it. And my children, our children, have all grown up to be successful members of the community. They have all gone on to get college degrees or VOTEC degrees. They have all decided, and I was firm, that they all be responsible citizens. Barry was always an encouraging husband. His statements to me have always given me comfort, strength, and encouragement. He would often tell me, "You are stronger than you give yourself credit for." Boy, did I have to hear that one thousands of times in my brain when things struggled. And I had to be strong. I was the only one left to support and raise these children. I've stated in the past, I've taken it upon myself to be Barry's voice. Since his voice was taken away on that tragic day 26 years ago. His voice is so important. He would just say, "Give me the facts." And the fact is, he was brutally murdered. Leaving the wife, children, grandchildren, father, brothers, sisters, nieces, and nephews to deal with the fact that Barry is no longer, the fact that Barry is gone from our lives here on earth forever. And I've told my children that Barry's death is a fact of our lives, and his love will always be with us. We as a family have held together and made it through some very hard times. We have buried family members. We have had weddings. We have had births. Our desire and our hope today is that justice will be served for our beloved Barry, and that you will take into consideration our statements and know that we have heard everyone else's testimony today so far, that we do not feel justly represented today in our council. I thank you for the opportunity to speak. And this is the family that has rallied around me for 26 years. Thank you.
Good morning. My name is Bridget Van Treese. I'm Barry Van Treese's daughter. When my father was murdered, I was 7 years old. On the day his body was discovered and those following his death, I recall my family gathering together, aunts, uncles, cousins, grandparents, all grieving the sudden and tragic loss of my father. For me, his death wasn't real until I saw his body laying in the casket at his funeral. And it was then that I understood that he was gone from our lives forever. When I was young, my father brought so much light and joy into our home. With his death, that light and joy was lost for a really long time. My dad would always find the good in any situation. His motto was just keep plugging. And that's what we did. We survived his death, and I'm forever grateful to my mother, who overnight went from a stay-at-home mom to working multiple jobs to keep us in our home and food on the table. As hard as she worked, it was barely enough, and eventually she could not afford our home and we had to move. Growing up without my father has affected me in many ways. I felt his absence keenly at every birthday and holiday, at my wedding, and at the birth of my daughter. As much as he is missed, I'm thankful for the man he was and the values he and my mother instilled in my brothers and I. My father taught us to value integrity, honor, and to always choose to do the right and kind thing. I feel that I personally have embodied these values in both my 14 years of military service and my service to my community as a healthcare provider. My brothers have all grown up to be good, kind, honest, and honorable men. For the last 26 years, we've waited patiently, trusting the legal system to serve the justice which was sentenced. I ask today to help us finally see that justice served. Thank you. And my brother Derek was joining us on Zoom.
Hi, Derek?
Can you hear me?
Yes, sir, we can. Please go ahead whenever we're ready.
Members of the board, and my name is Derek Van Treese. I'm the eldest of 5 children from my father's second marriage. I'm a United States Marine, devoted husband, proud father of 2 sons. I've honorably served my country and performed my civic duties. I've taken upon the mantle of being a liaison to the Attorney General Victim Services Unit for my younger siblings. I'd like to take just a moment to recognize and thank the men and women from that office who have worked diligently and provided unwavering support to our family and fought for us through the years. I'd also like to thank all the others that showed up here in support of our family, district attorneys and colleagues as well. One of the 14 leadership traits instilled in my service in the Marine Corps is integrity. Integrity means that you're honest and truthful in what you say or do. You put honesty, sense of duty, and sound moral principles above all else. Integrity is the ability of a person or institution to do the right thing, regardless of the need to be recognized or rewarded. It requires consistency in one's thoughts, actions, and words. My father always used to say that a man's word is his bond, and I've tried to live by that principle. I was at Marine Corps boot camp in San Diego during the first trial and conviction of Richard Glossip. As an 18-year-old willing to put my life on the line for my country, I had the expectation that back home the system was working as advertised. After the first conviction and sentencing, I thought the issue was settled. After several rounds of appeals, and as a slightly more jaded 24-year-old, I attended the second trial in person. I read every piece of case data, dissent, arguments, and recommendations I could get my hands on. I spent years being angry, frustrated, feeling helpless with this process, and a system that's supposed to work for the people by performing its duties as required by law. The senseless murder of my father occurred 26 years ago. 26 years. I spent over half my life waiting for justice to be served to those responsible. In that time, the state of Oklahoma has had 4 governors, 5 attorneys general, 7 directors of the Department of Corrections. There have been new laws enacted regarding the death penalty options. There's been a complete examination into the Department of Corrections policies and procedures regarding the death penalty protocols. There's been a multi-county grand jury, 2 independent investigations, documentaries, talk shows, and more. This case has been pushed from being a legal matter to being a political issue. It's been pushed from the court of law to the court of public opinion, and enough is enough. All due diligence has been served. 2 juries, 24 members of the public have listened to the same evidence. Both juries have found Richard Glossip to be guilty of his charges and rendered the same sentencing. Countless appeals, reviews, and hundreds of thousands of dollars and thousands of man-hours have been spent. The Court of Criminal Appeals just last week, with a unanimous 5-0 decision, once again denied post-conviction relief and the request to stay. The Court of Criminal Appeals response clearly shows that there is no new evidence and that the claims made by both the defense and the Attorney General were unwarranted, and there's no truth to the allegations presented. There are rules and procedures to change parts of law if we don't agree with them, but this is not the forum for that. And while I agree that the state must take all reasonable action to ensure adherence to the law, the information sent in the packet by the Attorney General of the board and that was discussed today by both the defense and the Attorney General is simply unconscionable to me. Every item listed has been rebutted in the appeals court answer. This unprecedented response shows an unbelievable level of disrespect to every person that spent the last 26 years working in this case and to our family. Enough is enough. The time is now. I urge you, I beg you to allow justice to finally be served through the word of law and the will of the people by denying clemency. Thank you for your time.
Thank you very much. We have some time. Alana, did you want to speak?
Alana
I'm sorry.
Vantrease Miletto, and I'm Barry's sister. This is our family. I just want to say, contrary to what I was going to say, is that today has just been a travesty. You have a clemency packet. You have the information. We have not been fairly represented today. This is an unprecedented situation to where yes, our Attorney General, our President Attorney General has brought these things up. They do need to be considered. At the same time, this is so one-sided. We have not been able to have the normal presentation that has gone on before all of these, before this day. And I know you don't need to hear a bunch of blubbering people up here, just, this is serious. This is so, it feels like a giant stab in the back, to be honest with you, because we have not been represented here today. We have information. We were there for every trial. We heard everything. We have studied, as Derek said, we have gone over and above to make sure that we don't want somebody to be executed that has not been decided by the courts of law and had every due process. I'm not an attorney, but I am a family member, and this could happen to anybody, and it does happen every day. We're just one of the many cases, but we need to be represented here. We need you to read your packet and see the other side of this. You have that information. Thank you for your time, and thank you so much to all of the district attorneys that have come here to stand for our family and to represent our family. And we appreciate all that you do and the difficult decisions you have to make. Thank you.
Thank you very much. Ken, did you want to speak? Is he on
So
Zoom? or-
Ken is not here, but
Okay.
my name is Carrie Jarbo, and I'm also Barry's niece, and my maiden name was Vantrease. And my father was also, my dad died when I was young, and I was 7 years old, and I was allowed closure. These kids that I sit next to, my cousins, were never allowed closure for the death of their father. And I do have a statement that from my cousin and my cousin Stacy and her parents, Ken and Linda Vantrease. Okay, well, and I can't get to all of this because she wrote a lot, but basically she was there immediately after finding Barry's body. They came to the scene, and she was there and saw the murder scene, and she sat across the table from Richard Glossip, and he lied to the entire family. He sat there and he lied to the police about what he saw and what he knew and what he did to cover it up. And we all know, our family all knows, that if it were not for Richard Glossip and the actions that he took preceding that terrible day, that my uncle would be here, their father, her husband, would be here today. And we have been unjustly represented. We feel, all of us feel that way. We know in our hearts that he is responsible for the death of Barry. And he has made it a spectacle. He reached out to Sister Prejean. He reached out to Susan Sarandon and Dr. Phil and probably Oprah. I don't know who all he reached out to, but he has maintained his innocence, but he's a habitual liar. He's become very good at lying about things, and to the point that I'm sure he believes what he's saying, and he's gotten others to believe what he's saying. But we were there for the testimonies and the jury trials, and twice he was convicted unanimously by a jury of his peers. And here we sit still today after all these. We've been there for all of this. Every time there's been an almost execution, we were there. And it's time for closure for this family. We need closure. The whole entire family needs closure. And I do appreciate you all being here and listening to us and our side and taking into account what we've been through all these years. And just thank you for that.
Thank you very much. Does the board have any questions for the Ventries family? No. Mrs. Ventries, I have a couple of questions. Was there any communication between the Attorney General's office and your family with regards to how these proceedings were going to go today, and any explanation for why the Attorney General has made the appeal that he has?
2 weeks ago, Attorney General Drummond gave a personal phone call to myself and my sister-in-law, and we were on speaker. He told us how it was going to come out in the media, and he said to us, with both of us hearing this, so there would be no miscommunication, that he was 100% believed that Richard Glossip was guilty of this murder. And what we were told that came out it was right before the press came out on this. And we understand that the procedures were going to be either, no, this piece of evidence did not make any difference. Yes, it did make a difference, and they would look at it and commute his sentence. And the third would be that there would be granted a new trial. But he believed that, number one, that the Oklahoma Court of Appeals would look at this issue of the mental health issue, and that was not disclosed, would be a null and void. And that's what the Court of Appeals decided, that was a null and void point.
Okay, thank you. I have another question for you, and I apologize that I'm asking this in advance.
That's okay.
Before the second trial in 2004, we have in our information that a plea agreement was presented to Mr. Glossip for him to plead guilty to murder in the first degree with the possibility of parole. And the notes in the file indicate that you were consulted and that you agreed with the DA making that plea presentation to him. Is that information accurate?
I know that the time of that trial that Glossip was firing his attorney as we were sitting there in the courtroom, and that there was a plea that came back. I don't remember the murder in the first degree. I do remember him wanting to plead manslaughter.
Okay.
And the family and I rallied and said no.
Okay. Do you recall a conversation with the district attorney's office where they had consulted you about having any conversations with Mr. Glossip about a plea agreement?
Only the one that I can remember was the manslaughter charge, and that was the day of.
Okay, thank you very much. I appreciate it. Any other questions from the board? No. Okay, thank you. If you could all return to your seats, we appreciate you being here this morning. And I know again how difficult this was for your family.
Thank you. We appreciate you and the job that you do. I know it is not an easy job. So we appreciate all of you and what you do for the state of Oklahoma.
Thank you.
Thank you.
Chair will now recognize Attorney General Gettner Drummond. And Mr. Drummond, you have 5 minutes for your summation, sir.
I deeply respect and appreciate the comments of the Van Treese family, and my heart continues to go out with them, to them. I've had the occasion to visit at length with Derek and Ken and Alana, and as well as Donna. And I believe that they have known my position from the beginning, that I'm troubled by this issue, but I would confirm that I believe that Mr. Glossip is in fact guilty of at least accessory after the fact. More likely than not, he's guilty of murder. But I do not believe that the evidence presents that he's guilty beyond a reasonable doubt, and that is my concern. I'd like to thank them for their comments. I'd like to also thank Mr. Duncan and Ms. Vitale for their hundreds of hours of input in this case. And I believe that when we view the cumulative nature of the facts that I have reached, the difficult decision that the state cannot proceed in confidence with the conviction that would result in the death penalty. I believe it was my request that the case be remanded to the Court of Criminal Appeals for a determination of these issues, and that was denied. So we are here today. I believe that this board should support a recommendation of clemency, and based on the complete record to include the evidence that the jury did not hear, I believe it would be a grave injustice to allow the execution of a man whose trial was plagued by many errors. Each of you can do your part today to ensure that that does not happen. Additionally, I want to address the one final aspect of Mr. Glossip's case that justifies recommendation of clemency. As you are aware, there were many factors that you consider when hearing the application of this nature. And that issue is whether the penalty appears to be excessive. I believe that in this case, there are two important reasons. First, as mentioned, Mr. Glossip did not murder anyone. One of the facts in this dispute, the one that everyone can agree on, is that the man who did brutally murder Barry Van Treese is in prison for the rest of his life. He's never going to get out. As Mr. Duncan said, and I'll say it again, to the extent that anyone should be executed for the murder of Barry Van Treese, the wrong individual is scheduled for the death chamber. I certainly understand the legal process of how Mr. Glossip was convicted of first-degree murder and the aggravating factor that allowed him to receive the death sentence. Nonetheless, I believe that death to be an excessive sentence for the man who did not commit this violent act, when the man who did will remain housed at the taxpayer's expense for the rest of his life. The second factor that makes me believe that Mr. Glossip's sentence is excessive is a letter that I received last night and that is in your packet from the Oklahoma County District Attorney, Vicki Bahena. She has written to the board and outlined that she has instituted new procedures and guidelines to govern when her office seeks the death penalty. She writes very clearly, and I quote, "I believe it is important for the Pardon and Parole Board to know that Mr. Glossip's case would not qualify for the death penalty in Oklahoma County under these new guidelines," close quote. If this case would not qualify for the death penalty today, then I believe that it would be an excessive penalty for the state to execute him. Members, I thank you once again for your service, and on behalf of the state of Oklahoma, and in the name of justice, I humbly ask that you support clemency. Thank you.
Thank you, sir, for being here. Chair will now recognize Mr. Knight for his 5-minute rebuttal. I'm sorry, did the board have any questions for the AG? Thanks.
And I yield to Amy Knight.
Yes, sir.
Good morning. We heard some concerns that there had been a completed legal process here, and I know you know this, but the existence of this process presupposes the completion of an entire legal process. We would not be here if that had not already occurred. Chief Justice Rehnquist wrote in Herrera versus Collins that, quote, "Executive clemency has provided the fail-safe in our criminal justice system. It is an unalterable fact that our justice system, like the human beings who administer it, is fallible, but history is replete with examples of wrongfully convicted persons who have been pardoned in the wake of after discovered evidence. He went on to explain that this process we are engaged in here today can correct the system's inevitable mistakes, and it is your ability to do that that makes this system with its known fallibility tolerable. This family that we heard speak has clearly been through a lot, and their pain is very real, and they do deserve justice, and they do deserve peace. Justin Sneed is not having a clemency hearing where they can express their loss. He is serving life without parole. Their very understandable pain and anger cannot be a reason for a government to proceed with ending the life of one of its citizens if the facts and law do not support it. We heard Oklahoma's chief law enforcement officer tell us a few minutes ago that the state made mistakes in its handling of this case. The state has an obligation to both crime victims and defendants to carry out its investigations and prosecutions thoroughly and ethically. In this case, the state has admitted that it failed to do that. That failure has caused immense suffering. Perhaps the family of Barry Van Treese would feel better if Mr. Glossip were executed. We can't claim to understand how they would feel. But their emotions cannot justify the state executing a man who did not receive the fair, thorough, and ethical process the state was obligated to give him, and who simply does not deserve it. The state has stepped up to own its mistake here. We would not be sitting here today if they had done their job right in 1997 and 2004. Oklahoma as a state must reckon with that reality. This board's task today is to decide whether to pass that choice on to the head of the government of the state of Oklahoma. What the state does here will be a defining moment, and we respectfully submit that this board should allow the governor to make that choice.
There are states in this great country that have decided not to use the death penalty. Oklahoma is not one of them. When a state decides to use this punishment to take the life of one of its own citizens, it must do so with utmost care. Earlier, we heard that great quote from the Oklahoma federal judge say, "God help us if ever in this great country we turn our heads while people who have not had fair trials are executed." You've heard that the state now admits that Mr. Glossip did not receive a fair trial. It is undisputed that there was poor police work, poor defense work, misconduct by prosecutors, loss and destruction of critical evidence, and lies from the state's chief witness and witnesses that were never heard.
Jennifer, can you hear us?
Yes, ma'am, I can hear.
Is OSP on?
Yes, sir.
They accepting the invitation?
They're there. They just, you have to speak.
Okay. As I stated at the beginning of the hearing, the board received notice that Mr. Glossip has elected to appear before the board. The chair now recognizes Mr. Glossip for 20 minutes to address the board. Once he comes online, we'll continue. Good morning, Mr. Glossip. Can you see and hear us?
Yes, I can.
Sir, would you please raise your right hand? Do you swear that the information that you're going to provide to the Oklahoma Pardon and Parole Board this morning is the truth?
Yes, I do.
Would you please state your full name and DOC number?
Richard Eugene Glossip, 267-303.
Thank you, sir. Mr. Glossip, you're here today seeking clemency for Oklahoma County case CF 1997-244, murder in the first degree. Is that correct, sir?
Sir.
Mr. Glossip, we've heard presentations from your attorneys, representatives from the Attorney General's office, and from members of Mr. Vantrese's family. You have 20 minutes to share what you would like the Pardon and Parole Board to know. At the end of that time, members of the Pardon and Parole Board may have questions for you. Do you understand the process that we are going to follow this morning?
Yes, sir.
Thank you. Please go ahead and tell the board what you would like them to know.
First, I want the Vantrease family to know how terrible I feel for what they have gone through. What your family has gone through, no family should ever have to endure. I must say again for this hearing that I did not know about Justin Snead's plan to commit any crime against Barry Vantrease, and I would have never thought of paying anybody to commit a crime. I absolutely did not cause Justin Snead to commit any crime against Mr. Vantrease, let alone to murder him. I know that in the chaos of Mr. Vantrease's death, I made mistakes in how I responded. I'm deeply sorry that in my fear and confusion, I caused anyone any further harm. Today, I want to thank many people who have taken the time to look at this case closely and to take a stand about it. Grateful to Representative McDougal and Humphrey and the 62 other legislators who insisted on an independent investigation into my case. I'm grateful for Justin Jackson, who listened to me and was my friend. Grateful to Reed Smith's law firm, who gave their time without pay to take a close look into my case. I'm grateful for Attorney General Drummond, who called on Special Counsel Duncan to conduct a separate independent investigation that concluded my conviction is not reliable and could not stand. I'm grateful for Governor Stitt, who issued 2 reprieves, allowing time for these 2 independent investigations to reach their conclusions. I know these steps were not easy. I consider myself extremely fortunate to have had the people stick their necks out because they believed this was the right thing to do. Finally, I am grateful for my wife, Leah, who has stood by my side with all the tough times we have faced, never wavering in our faith and commitment to each other, and for keeping me strong every step of the way. I'm not a murderer, and I don't deserve to die for this. Please give Governor Stitt a chance to commute my sentence. Thank you for this opportunity, and God bless you all.
Thank you, sir. Do the members of the board have any questions? Okay, Mr. Glossip, none of the members of the board have any questions for you this morning. Is there anything else you would like us to know or that you would like to say before we move on?
No, sir.
All right. Thank you very much for being here this morning and participating in this hearing.
Thank you.
Thank you. We will take a brief 10-minute recess before final discussion by the board and calling for the vote. It is now 12 noon and the hearing is out of recess. We will now move on to any final questions and discussion by the board. Do any members of the board have any additional questions for the participants today? No. Is there any discussion? We will now vote on the question of clemency for Mr. Glossip. Ms. Romero, would you please call the vote?
Ed Konechny,
Yes for clemency.
Calvin Prince,
Yes, for clemency.
Richard Miller,
No.
Kathy Stoker. No. Clemency is denied.
Please, no outbursts. Before we adjourn, I want to remind everyone that for security purposes, please remain seated until the officers excuse each group. I want to thank everyone for being here today and for your cooperation and respect of these proceedings. This special meeting of the Pardon and Parole Board is now adjourned.